Good morning, everyone. This is the first microphone check for captions test. Mic check 1, 2, 3. Microphone check 1, 2, 3. Once again, good morning, everyone. This is the first check for captions. Microphone check 1, 2. Microphone check 1, 2. Good check. Thank you. Good morning, everyone. The time is now 9:15. This is the second captions test. Microphone check 1 2 3. Microphone check 1 2 3.
Well, good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, February 21st, 2024. The time is 9:31 a.m. And the dais looks a little different today as we welcome our newest commissioner, Caterina Gonzalez. Commissioner Gonzalez replaces Emily Lindley, whose term expired in August, but who remained at her post until Commissioner Gonzalez's appointment. And we are certainly grateful for Emily Lindley's service to the state and look forward to celebrating her in a different forum. Commissioner Gonzalez, welcome. We look forward to your leadership. For those of you who don't know, Commissioner Gonzalez has a deep background in environmental law and policy, serving most recently as a policy advisor with the governor's office. So welcome. The rest of the dais may look familiar. We're joined by Commissioner Bobby Ginecca, our general counsel, Mary Smith, and I am John Neerman. I'd like to, or let me just say this, I appreciate your patience for one more TCEQ family matter, and that is to recognize the outstanding 35-year career of Feroz Fahora, who's dedicated his work to serving the people of the state of Texas, to this agency's mission of protecting public health and the environment, through his work in the domestic wastewater permitting section. And Feroz has a degree in civil engineering. He's worked internationally as well as here in Austin in the public and private sector, all of that before coming to TCEQ, or rather its predecessor agency, the Texas Water Commission, back in 1988. Yeah. Feroz has worked on over 1,500 permits, has attended 100 plus public meetings, has testified numerous times at the State Office of Administrative Hearings as an expert witness. He is respected in his field as a technical expert within the agency. Not only do we respect and appreciate his technical expertise, but he has been a highly valuable leader and mentor for the agency. So Feroz, for your consistency, for your excellence, for the pride that you have brought in carrying out this agency's mission to protect public health and the environment, we greatly appreciate you. Thank you, sir. And I have a little something for you, a token of appreciation from some of your colleagues, and I'll bring it down to the podium there for you. This is an oversized retirement card. Quite many of you have.
Good morning, commissioners and chairman, and all the folks from the outside, inside, because I don't know to name everyone, obviously. Most of the people I know personally for a long, long time, multiple decades. And for me, this was a journey of passion, how to help my adopted state. I cannot pay back to enough to my state of Texas. So I did whatever I could with my limitation to my best of my ability. And I was supported by the best of best in my staff members, my management, my upper management, all the way to the commissioner level. I had nothing but good relation. And this gave me the opportunity to continue my job. Personally, I had my own limitation. My wife has the health issues, and that forced me to retire because I cannot have enough help for her. So for me, this is not the volunteer retirement. I want to break the record of my other co-worker in the office, Louis Herring, but I could not. Of course, he is still going on, just like, energized bunny, keep going and going. And I said, I cannot do that kind of stuff. I had to step out. But for me, I had sent the legacy. I hope the people remember that I did my part, and I'll be still available for any information they need to seek for me, and always thankful to my management. They always supported me, they trusted me, and even attorneys trusted me. How about that? So thanks for everything. Appreciate it.
There's a vision for this. I'm not sure what it is, so I'll just send it along with you.
Appreciate it.
All right, let's get going here. Registration for this meeting has now closed, but if you'd like to address the commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to speak to, and we will do our best to accommodate that request. Alternately, you can register at the table out front. And with that, Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the application for amendments and renewals of underground injection control permit numbers WDW 344, 345, 346, 347, 348, 349, and 350 by U.S. Ecology Winnie LLC. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Thank you, Ms. Smith. So, colleagues, this item 1 is the first of a half dozen hearing request items on the agenda this morning. So I want to take a few minutes just to lay out in more detail than I normally do our process for analyzing requests for contested case hearings, and then we'll refer back to that during our discussion. So the analysis really begins with the threshold issue of whether there's any right to a contested case hearing. And in the case of a renewal or amendment, if the 5 conditions that are set forth at 30 Texas Administrative Code Section 55.201I5 are satisfied, there is no right to a hearing, and we must deny all hearing requests. The first condition at that provision I cited usually is dispositive, and that is whether or not the application seeks a significant increase in the quantity of pollutants that are discharged or emitted. So we typically refer to these applications as no increase renewals. The other required conditions relate to the place and pattern of the emissions or discharge, the quality of the pollutants, notice, comment, and the applicant's compliance history. And then if we get past that threshold question, and we normally do, we typically analyze the requests in 2 parts. So the first part of our analysis relates to standing, and that is who has a right to a hearing. The second part relates to which issues are appropriate for referral. So concerning standing, 30 Texas Administrative Code, Section 55.201 provides that an affected person may request a contested case hearing, and then Section 55.203 defines affected person. And really the heart of this analysis is whether the requester has articulated a personal justiciable interest, meaning an interest that is not common to the general public, and one that is protected under the law under which the application is considered. In addition, requesters must articulate their personal interests both in timely comments and a timely hearing request. Section 55.203 also provides for standing for governmental entities if the entity has a statutory authority or another interest in issues relevant to the application. And under Section 55.205, associations can have standing if the interests they seek to protect are germane to the organization's purpose, if their request identifies a member who would have standing in their own right, and the participation of that member is not required. So assuming that at least one requester has met all of the procedural and substantive requirements to be entitled to a hearing, we then consider which issues are appropriate for referral to SOA. And here our analysis follows 30 Texas Administrative Code, Section 50.115C, which allows the referral of factual questions or mixed questions of fact and law that affected persons have raised in comments and in a successful hearing request, and that are relevant and material to the decision on the application. And another way to describe what is relevant and material is to say those issues that are within the commission's jurisdiction on a particular application. For example, impacts to a requester's health and to the environment, as well as procedural requirements, generally are relevant and material, but noise, traffic congestion, and property values generally, nearly always, are outside the commission's jurisdiction. In addition, air emissions on a water quality application are not within our jurisdiction, and vice versa. So, colleagues, thank you for bearing with that exposition. I just think it's helpful from time to time to spell out in greater detail how we approach these requests. And like I said, we have a half a dozen in front of them. On this first item, there is no threshold issue, so we are considering requesters who have joined in submitting two separate requests. The requests are adjacent property owners who have demonstrated that they may be affected in a manner different from the general public because of concerns that migrating waste will affect their mineral interests. And these interests in the deep subsurface are not absolute or exclusive, but I think they are sufficient to establish standing. So I would grant the hearing. And as for the issues, I would refer the question of whether any existing right, including mineral rights, will be impaired by the applicant's activity. And I would allow 180 days for that hearing. Commissioner Ginecca.
I'm so taken aback by going first. I'll say that I'm going to say a little more than I probably should because this is close to the former area that I've worked in this agency, and I think it's an interesting issue because this is a fight about nothing. It's about negative space under the ground, and the activities that the applicant would seek to do, I think, do impact the open space, the use of that space that the adjacent the other party, who I agree with you, is an affected person in this instance, raises. I think the issue, as you frame it, is well stated, and that was the only issue I found.
Great. Commissioner Gonzalez. Nothing to add? Are we ready for a motion?
I move that we grant the hearing requests of Grayson Eden Pipkin, Bruce Fletcher Pipkin, and Pipkin Ranch Holdings, LP, that we refer the application to SOA for a contested case hearing on the following issue: whether any existing rights, including but not limited to mineral rights, will be impaired by U.S. Ecology's injection of industrial and municipal non-hazardous waste in accordance with Texas Water Code, Section 27.051A2. And finally, move that we set the hearing duration for the proceeding at 180 days from the date of the preliminary hearing to the issuance of the proposal for decision.
Let's second that.
All right. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the consideration of the application by Waste Corporation of Texas LP for a major amendment to MSW permit number 1586B. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, on this item, we have a single requester who failed to raise any issues, and because the individual did not demonstrate a personal interest, we're required to deny this request. Commissioner Ginecca.
I arrived at the same analysis.
Commissioner Gonzalez.
I agree.
I think we're ready for a motion.
Let me do this one. Okay. I move that we deny the hearing request of Sigfredo Ruiz, issue the major amendment to municipal solid waste permit number 1586B to Waste Corporation of Texas LP as recommended by the executive director, and adopt the executive director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the consideration of the application by Aguilas Robles LLC for amended tip deeds permit number WQ0015843001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So on this item, colleagues, the requester's property interest is adjacent. However, it's expressed affected economic interest with respect to its future ability to construct its own treatment facility, in my view, is too speculative to confer affected person status. And I was at a loss to identify any disputed question of fact that's relevant and material to the amendment application. So I would deny the hearing requests. In addition, the request for reconsideration does not add any new information that was not already considered as in connection with the executive director's response to comments. So I would deny that request as well. Commissioner Janeka.
I reached the same analysis, and it was, the keyword was disputed. I think they answered a question that they appeared to open in their first comment. So I'm with you on finding effectiveness.
Great. Commissioner Gonzalez.
I agree.
I think we're ready for a motion.
I move that we deny the hearing requests and request for reconsideration of Catalanian LLC, issue amended tip deeds permit number WQ0015843001 to Aguilas Robles LLC, and adopt the executive director's response to comment.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is consideration of the application by Greenwood Ventures Group LLC. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
So colleagues, I count 7 requests on this item. The first is from the Guadalupe Blanco River Authority, which is a governmental entity and which cites its legal authority over water quality, among other interests. GBRA has also met the other procedural and substantive requirements to be considered an affected person, so I would grant its request. We next have 2 associations. The Greater Edwards Aquifer Alliance failed to identify a member who would have standing in their own right, so we have to deny that request. The San Marcos River Foundation expresses concerns about water quality. These interests are germane to its purpose, and it has identified Mr. Doyle as a member who would have standing in his own right. Because Mr. Doyle owns property along the discharge route within about 3/4 of a mile of the discharge point, he may be affected in a manner different from the general public. So I would grant the San Marcos River Foundation's request. Ms. Winklerek and Mr. Edmondson fail to state how they would be affected by the proposed facility in a manner different from the general public, so I would deny their requests. Larry Lindsay's sole concern is flooding, which is outside the commission's jurisdiction on this application, so I would deny his request as well. And finally, that leaves us with Colby and Aaron Stevens, who own property adjacent to the proposed facility, because they raise concerns about odor, which is relevant and material to this application, and have met the other procedural and substantive requirements. I would grant their requests. So let me pause there before I turn to the issues and get your feedback. Commissioner Janeka.
I arrived at the same spot.
Commissioner Gonzalez.
Agree.
Okay. As for the issues, I would refer whether the draft permit is protective of water quality in the receiving waters, whether it adequately addresses nuisance odors, and whether the anti-degradation review complies with the applicable rules, including with respect to nutrients, and I would allow 180 days for the hearing. Commissioner Janeka.
I'm comfortable with that proposal.
Thank you.
Okay, I think we're ready for a motion.
I move that we grant the hearing requests of the Guadalupe Blanco River Authority, Colby and Aaron Stevens, and the San Marcos River Foundation, that we deny the remaining hearing requests, and that we refer the application to SOA for a contested case hearing on the following issues: with a concurrent referral to the Alternative Dispute Resolution Program. A, whether the draft permit is protective of water quality in the receiving waters in accordance with applicable regulations, including the Texas Surface Water Quality Standards and 30 Texas Administrative Code, Chapter 307. B, whether the anti-degradation review complies with applicable regulations, including whether the draft permit includes adequate nutrient limits. And C, whether the draft permit adequately addresses nuisance odor in accordance with 30 Texas Administrative Code, Section 309.13, and that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the consideration of the application by Preserve Hutto LLC for new TIPD's permit number WQ0016145001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So we have 8 requests on this item. The first 2 are from governmental entities. The Williamson County Water, Sewer, Irrigation, and Drainage District Number 3 is situated adjacent to the proposed facility. It has capacity to provide wastewater services, and it has plans to expand its treatment facility. The district has raised concerns about regionalization and need. I think it has demonstrated a personal justiciable interest, and having met the other procedural and substantive requirements, I would grant its request. The city of Hutto also provides wastewater services. The proposed facility is within the city's extraterritorial jurisdiction and its wastewater CCN, and the city has raised concerns about regionalization. So I think it's also demonstrated a personal justiciable interest, and I would grant its request. Karen Blakey resides about a half mile from the proposed facility and raises personal concerns about odor and human health, which are relevant and material to this application. I would grant her request. Mohammed Halak raises health concerns. He resides about 3/4 of a mile from the proposed outfall. And keeping in mind that this is a relatively modest discharge of 48,000 gallons per day, I would nevertheless consider him to be an affected person, affected in a manner different from the general public, and I would grant his request. The requests by Megan McMillan and Judy Scogan are similar in that they each pose a series of questions, and they ask how the community might be affected without ever stating how they would be personally affected. And colleagues, for me, this request falls short of what our rules require, so I would deny their requests. And finally, Charlie Adler and Travis Scogan identify no interests or issues, so we should deny their requests. And let me pause there and see how y'all came out.
It's consistent with my analysis.
Yep, in agreement.
Okay, turning to the issues, I've identified 3, whether we should deny or alter the terms of the draft permit based on the policy of need or regionalization, whether the draft permit complies with nuisance odor requirements, and whether it is protective of water quality, including the health of the requesters and their families, and that is protective of existing uses of the receiving waters. Actually, 4 issues. I want to include a notice issue on that, whether notice was adequate. And again, I'd allow 180 days for the hearing. Commissioner Janeka.
I'm comfortable with that motion.
Yes, agree.
All right, I think we're ready for a motion.
I move that we grant the hearing requests of Karen Blakey, Mohammed Halak, the City of Hutto, and Williamson County Water, Sewer, Irrigation, and Drainage District Number 3. I further move that we deny the hearing requests and the request for reconsideration, and move that we refer the application to SOA for contested case hearing on the following issues. Issue A, whether the commission should deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code 26.0282 and the general policy to promote regional or area-wide systems under Texas Water Code 26.081. Issue B, whether the draft permit complies with applicable requirements to abate and control nuisance odors as set forth in 30 Texas Administrative Code 309.13E. Issue C, whether the draft permit is protective of water quality, including the protection of the health of the requesters and requesters' families and the existing uses of the receiving waters in accordance with applicable regulations, including the Texas Surface Water Quality Standards and 30 Texas Administrative Code, Chapter 307. And issue D, whether the applicant substantially complied with TCQ's public notice requirements in 30 Texas Administrative Code 39.405. And finally move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Can I make a clarification? You said deny the hearing request. Did you mean deny the remaining hearing requests on that one?
Thank you. Yes, ma'am. I
okay.
clarify that we deny the remaining hearing requests and the request for reconsideration.
With that amendment, do we hear a second?
Yes, I second that.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 6 is the consideration of the application by Montgomery County Municipal Utility District Number 125 for a renewal of Texas Pollutant Discharge Elimination System Permit Number WQ149890001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Colleagues, I had referenced the threshold question. This application satisfies all of the conditions as a no increase renewal under 30 Texas Administrative Code, Section 55.201I5. So there's no right to a hearing, and I would deny this request.
I agree.
I agree. I move that we find that there is no right to a hearing on this application pursuant to Texas Administrative Code, Section 55201I5, deny the hearing request of James White, and issue the renewal of Texas Pollutant Discharge Elimination System Permit Number WQ0014989001 to Montgomery County Municipal Utility District Number 125 as recommended by the Executive Director, and adopt the Executive Director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which are items 7 through 24, and the Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Michael Parrish of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 7 through 24. The total assessed administrative penalties are $333,311, with $25,525 deferred, $56,171 applied towards supplemental environmental projects, and $251,615 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Mr. Parrish. I have none. Any questions, colleagues? Seeing none. Ms. Smith, has anybody signed in to speak?
On item 8, we have an individual who's available to answer questions, but no one who's asked to address the commission.
Thank you. Mr. Arthur, what say the Office of Public Interest Counsel?
Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports adoption of these enforcement orders as presented by ED staff.
Thank you, colleagues. I do as well.
I move that we adopt items 7 through 24 as recommended today by the Executive Director.
Second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 25 is the consideration of the monthly enforcement report, and the executive director's staff is here to present this one too.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Craig Pritzloff, Office of Compliance and Enforcement, and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2024 through December. There were 214 effective administrative orders issued, and of those, 39 contained supplemental environmental projects. These orders assessed a total of $4,796,510 with a payable amount of $1,930,433. $2,511,959 are to be paid towards supplemental environmental projects. 4,544 notices of violation have been issued either through our field offices or review of self-reported data in our central office, and 542 enforcement action referrals have been received. There are 2,707 pending administrative orders with 1,558 cases that are on the backlog. 180 cases are pending at the Attorney General's office for representation in district court, and 3 judgments have been issued. 1,912 cases are being tracked for compliance. We are available to answer any questions you may have.
Thank you, Ms. Sedemeyer. I have none. Colleagues, any questions?
No questions.
I have a question for Ms. Sedemeyer, perhaps a question I'd like to pose to the two of y'all. We rarely ever get to talk about anything unless the public gets a chance to know about it. I really would love to talk a little more about SEPs and recognize how much that's a wonderful program. It's a tremendous and needed and valuable activity that our agency engages with entities coming back into compliance. I want to acknowledge that those, I think, add time and complexity and drag out the duration of these enforcement matters as you're dispensing with them, where, frankly, at this time, we're really addressing and focusing on a backlog, a growing workload that I think partly the Texas Miracle has translated into just more impacts where our staff have engaged. I'm also recognizing opportunities, perhaps, of where we could do more to talk about our SEP projects that are awarded once they're awarded, to help add that context to the matters where our agency brings regulated entities into compliance, and there's some fine or fee associated where that can get pulled down to a program or a project that much more directly benefits or remediates the issues. Compliance SEPs are another great issue. If that poses concerns from staff and talking about them at the same time when there may be opportunities for the public to still contest and want us into a court, I respect that. I think that's part of why our agency has always looked so stodgy and we're inescapably bureaucratic in our process, because we're very thoughtful about the controversy around all the things that we do. But what are y'all's thoughts, colleagues? How much do talking about our SEP projects versus trying to move things quickly seems to be a paramount priority right now for you?
Sure. Ms. Sedemeyer, can you repeat the number, the dollar figure for SEPs, and remind us of the time period that covers? You mentioned it in your report, and I didn't jot it down quite fast enough.
Yes, sir. So through December of 2023, we have $2,511,959 towards supplemental environmental projects. 39 of our orders have contained supplemental environmental projects.
Thank you for that. And so these dollars are doing a lot of good in our communities, whether it's helping fund cleanup of hazardous waste or connecting households to septic services where they may not have the resources to do that, and so on. At the same time, because we value this authority that the legislature has given us, we exercise it very judiciously. I guess we're here on this item to just get a report on it. I know at some point in the last couple of years, I think we had a work session on SEPs, and maybe we should tee that up again. It might be a more appropriate forum for having a wider ranging discussion on the topic. But I agree. It's a very helpful authority, and it does a lot of good in the communities that we serve. Commissioner Gonzalez, do you have additional thoughts on SEPs?
I've always been a big fan of them, dating back to my local government days. So they do a lot of very good things in the community, and be interested in doing a work session in the future, see how we can improve on the process or highlight if the process is working.
Appreciate that.
I'm elated to hear it, and I appreciate it. I apologize for raising the issue unexpectedly on everyone, but thanks for the comments.
Thank you, Commissioner. Ms. Smith, is anybody signed in to speak on this item?
We don't have anyone on this one.
Thank you. And Mr. Arthur, what are your thoughts?
OPIC has no comment except to say that we appreciate the report.
Thank you for the report. Colleagues, no action is necessary on this item, so Ms. Smith, I'll ask you to please call the next items.
So that will take us to our items 26 through 29, which are the quadrennial rule reviews for chapters 214, 295, 317, and 350 of Texas Administrative Code Title 30. The Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Gwen Rico with the General Law Division. Pending before you are items 26 through 29, the adopted rule reviews of 30 Texas Administrative Code Chapter 214, secondary containment requirements for underground storage tank systems located over certain aquifers, Chapter 295, water rights, procedural, Chapter 317, design criteria prior to 2008, and Chapter 350, Texas Risk Reduction Program. As required by Texas Government Code Section 2001.039, Executive Director's staff conducted a rule review of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notices for the review of Chapter 317 was published in the January 6, 2023 issue of the Texas Register, and the proposed notices for the reviews of Chapters 214, 295, and 350 were published in the August 25, 2023 issue of the Texas Register with 30-day comment periods. No comments were received for these rule reviews. Based on the review of these chapters, the Executive Director has determined that the reasons for the rules in Chapters 214, 295, 317, and 350 continue to exist, and changes to the rules identified as part of this review process will be addressed in a separate rulemaking action in accordance with the Texas Administrative Procedure Act. In conclusion, we respectfully recommend approval of the adoption of the rule reviews of Chapters 214, 295, 317, and 350. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and staff attorneys assigned to these chapters are here to answer any questions.
Thank you, Ms. Rico. I have none. Colleagues, any questions?
No, thank you.
No questions.
Seeing none, Ms. Smith, is anybody signed in to speak?
No one has signed in on these.
Mr. Arthur?
OPIC agrees that the reasons for initially adopting the Chapter 214, 295, 317, and 350 rules continue to exist, and we support readoption of the rules in each of these chapters.
Thank you, Mr. Arthur. And I just point out again, there are no comments. I'm ready to adopt the review and readopt these rule chapters.
I move that we adopt the rule reviews and readopt the rules in 30 Texas Administrative Code Chapters 214, 295, 317, and 350 without amendment as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next items.
The next items are for closed session, and the commission will meet in closed session in room 4222, Building F, at 10:15. approximately 10:15 a.m., as permitted by the Open Meetings Act, including Texas Government Code Sections 551071 and 551074, to take up and consider matters pursuant to item numbers 30 through 33 as posted and noticed.
The time is 10:10 a.m. We are in recess.
The commission met in room 4222, Building F, for closed session from 10:26 until 11:04 a.m. approximately on items number 30 and 33, as posted in notice pursuant to Texas Government Code, Section 551.074. No action was taken. This agenda stands adjourned. The time is 11:19.